Asia and beyond. Welcome to another program of Issues in the News. Leslie Mongal, Positive Mind, Pam Singh, Arjun Jawahir, Moses Chinan, Chandra Sukraj, and all of you, hundreds of you who are already on the live. Welcome to another program of Issues in the News. Share the program. Press that share button on your phone, on your computer, on your iPad, or whatever device you're using to view this program on. Share it so that you, your followers, and your friends can join us in tonight's discussion. Use the comments section to express your views, ask questions, raise queries, and invite me to address any issues you may wish to discuss. Remember, this is an engaging program. This is an educational program. We want to learn from each other. That is the main objective of this program. So if you wish to raise an issue that you want me to address, please let's do so. If you want to share information so that I can share it with the rest of the viewers, then use the column section of the program to do so. I want to engage. If I don't get to answer the questions, next week I will try to address whatever issues you raise. So let's start the ball rolling. I said a few weeks ago that this grouping on the opposition benches in the National Assembly of the 13th Parliament is the most inexperienced grouping of parliamentarians we have had in our National Assembly, perhaps since independence. And we are beginning to see evidence of that inexperience, not unexpectedly. I received via email from the clerk of the National Assembly a draft bill under the caption Bill number 12 of 2025, and it's intituled the Natural Resources Fund Amendment Bill of 2025, and it is signed by Terence Campbell, MP, Partnership for National Unity, dated November 3rd, 2025. I have seen excerpts of the bill and news stories regarding the bill in the mainstream media, so you may not be unfamiliar with the bill about which I am speaking. Now, the Parliament, as you know, or the National Assembly rather, is governed by the Constitution and by the standing orders of the Parliament. And parliamentarians are bound by the standing orders and by the Constitution. And so is the Speaker and, of course, the Clerk. These standing orders have been in force since Guyana became an independent territory. A few changes have been made over the years, but they have largely remained the same. And they were inherited from the colonial assembly. So they are not new rules that are governing the manner in which the National Assembly is regulated. I say that because I don't want to open myself to the criticism that the PPP made these standing orders recently. These standing orders have survived several governments. There were changes along the way, but not fundamental changes. The APNU AFC government was there from 2015 to 2020, and they made no significant change to the standing orders which currently exist. The main changes that were made were, I believe, done in the early 2000 period. So the standing orders have largely remained the same. Now, those standing orders provide very clearly that the National Assembly cannot proceed to debate or deal with a matter if that matter is sub judice or sub judice, meaning that it is pending in the court system of our country. That rule is one that is grounded in the separation of powers doctrine. Parliament is an independent arm of government, as is the judiciary and as is the executive. And they have exclusive functions, and in some cases, the executive and Parliament intersect in their functional responsibilities. But the judiciary is always independent of and separate from these two other branches. And that is an entrenched principle in our Constitution, and the provisions of the Constitution are fashioned accordingly. The standing orders of our Parliament are also structured to recognize and respect that doctrine. So once there is a matter that is occupying the court, Parliament, as a matter of the standing orders, prohibit the consideration of that matter by the National Assembly. And that rule is contained in Standing Order 41, subparagraph 2 or subrule 2. And it is in the discretion of the Speaker to determine whether the matter is sub judice or not. And speakers have consistently, over the years, upheld this outstanding principle without exception in relation to either side of the House. So, Mr. Campbell, on February the 20th, 2024, filed in his own name, Terence Campbell, legal proceedings against the Attorney General and the senior minister within the ministry, senior minister in the office of President with responsibility for finance. He was represented by Roysdale Ford, senior counsel. And in these proceedings, there was a frontal challenge to the constitutionality and legality of the Natural Resource Fund Act. And the entire case attacks the Act and seeks several remedies from the court in relation to the Act, the Natural Resource Fund Act. It is not necessary for me to share the reliefs or the remedies that Mr. Campbell is seeking before the courts. But if you wish, you can obtain a copy from the court. But trust me when I say that the entire purport and thrust of this litigation is an attack on the constitutionality of the provisions of the Natural Resource Fund Act. He makes several allegations in relation to mainly 2 or 3 provisions of the Act. In particular, Section 16 of the Act. That is the main focal point of the action, among other things. Section 16 of the Act, in particular Section 16, subsection 2. He wants the court to grant him a several declaration in relation to Section 16 of the Act. And he wants the court to make an order or make several orders directing the Attorney General and the Minister of Finance to do several things which he claims that Section 16 of the Act requires to be done. This case is ongoing before the High Court and was being heard by the then acting Chief Justice, the Honorable Roxanne George, Senior Counsel. All the paperwork required to be filed were filed by all the parties involved, and the judge heard submissions from Terence Campbell's lawyers, who included Roysdale Ford, Sinat Jairam, and Christopher Ram. And yours truly appeared in person as the Attorney General of Guyana, and I represented the senior minister in the office of the President with responsibility for finance. This case remains pending before the High Court. This bill, signed by Terence Campbell, and that he's attempting to get put before the Parliament, seeks to amend the very Section 16 and to get through this amendment the very remedies that he's seeking in the court. In other words, the very thing that he's asking the court to grant him, he is now in the Parliament seeking to achieve those very objectives through a purported amendment or purported amendments to the Natural Resource Fund bill. In short, he's prosecuting his cause simultaneously at two different fora, in two different arms of government. The Constitution itself does not contemplate that and doesn't provide for that and will not permit that. The court system itself, had he gone to two courts to prosecute the same cause, one court would have held that that process would constitute an abuse of process of the court. And he would have had to elect which proceedings he will proceed with, for want of being repetitive. The same principle applies to the parliament. You cannot prosecute your cause in both of these arms of government. And the standing orders, in any event, prohibit him from so doing. And many of you look at the parliament and you look at the debates and you know of the sub judice principle. Now, I don't know if Terence Campbell is not seeking legal advice, or those who are advising him are ill-advising him, but these are established, uncontroverted principles of law and of parliamentary practice that at least one should familiarize him or herself with when you go into parliament, or as you're about to go into parliament. The other issue that I want to raise in relation to this purported amendment is this. When I examined what Mr. Campbell is seeking to amend the Act to achieve, I come to the conclusion that the purported amendment is more stylistic. It is more a matter of form than of substance. And I don't know whether you would want me to bore you with reading what the Natural Resources Fund Act says and what Mr. Campbell wants it to say by these amendments. It's a matter of splitting hairs. The Act says all withdrawals, 16.2 I am reading from, and he wants to amend 16.2. All withdrawals from the fund shall be deposited into the consolidated fund and shall be used only to finance A, national development priorities, including any initiative aimed at realizing an inclusive green economy, and B, essential projects that are directly related to ameliorating the effect of a major natural disaster. When you read what the gentleman wants the thing to be amended to say, it is largely the same thing. He says all withdrawals from the fund to the consolidated fund, he doesn't say shall deposit in, but weird language, all withdrawals from the fund to the consolidated fund shall, upon deposit, constitute an integral part of the consolidated fund and shall be governed by the provisions of this Act. The matters of the consolidated fund is always governed by provisions of different acts. But most importantly, it is governed by the Constitution. It's the Constitution that creates that fund. And he says, for the avoidance of doubt, the revenue shall not be used to support some recurrent expenditure and shall must be used to only, only to finance infrastructural development projects of the government, including any initiative aimed at realizing an inclusive green economy. The same thing that we have here. National development priorities, including initiatives aimed at realizing an inclusive green economy. The two things are saying the same thing. The next one is essential projects that are directly related to ameliorating the effect of a major natural disaster. This is what he wants it to say. Two essential projects that are directly related to ameliorating the effects of a major natural disaster. The thing is same thing, identical thing. No government will support amendments that are in form only to amend its own legislation. You want the thing to be written with some different language, Mr. Campbell, you have to win the government. You can't win 12 seats at an election and want to make objections to the government legislation that hardly makes material difference or material differences. You may not like the language in which it is expressed, and you want to change the language, you need to win an election and win the government. You can't get 12 seats and want to dictate to the government that they must support you to change, to make, you're saying the same thing what the bill says. I don't know, these people don't read. And the other parts of the amendment are inconsequential, some renumbering of something to say. Please look at the amendments, the journalists I'm speaking to, look at what Mr. Campbell wants to amend and look at the act. The act can be got, you can get it from the official gazette, Friday 31st December 2021, edition of the official gazette, Friday 31st of December 2021. You'll get a copy of the act and look at what Mr. Campbell is purporting to amend and tell me if there is any material difference. So quite apart from the prohibition imposed by the standing order, the purported amendments themselves lack merit and is almost an abuse of the parliamentary process and would be insulting and insultive to any government that this amendment is inviting to review the government's legislation, but to make no serious changes to it. So this set of amendments that Mr. Campbell wants the National Assembly to consider, in my humble and respectful view, ought not to see the light of day because it abysmally fails to meet the required standards and it is prohibited by the relevant standing orders. And that is why I say that this program is for us to share information and share knowledge. So, many of you will recall the case of Frederick Collins, Godfrey White, ExxonMobil Limited, and the EPA. Remember those names? Frederick Collins, White, Godfrey White, ExxonMobil, and the EPA. This is the case involving the unlimited guarantee. Recall, this case was heard and Justice Sandil Kisun made certain orders and made certain declarations in relation to a guarantee, and that decision was appealed. It's referred to in the press and was referred to publicly as the unlimited guarantee case. Recall, the Attorney General was not in the case, but after the case was concluded and when an appeal was filed by the EPA and Exxon, the Attorney General joined the appeal. The Court of Appeal refused to allow the Attorney General to join, and the Attorney General had to go to this Caribbean Court of Justice to get permission to join. The Caribbean Court of Justice, after hearing submissions from the Attorney General, granted him permission to join. Well, that appeal, with the Attorney General now joined, is fixed for hearing in the Court of Appeal of Guyana on the 20th of November. 20th of November, that is later this month. It's an important appeal, and important issues of law will be addressed and hopefully decided upon in that case. I want to speak a little on Forward Guyana. What's the name? FGM, Forward Guyana Movement, because they have embroiled the Attorney General in a series of litigation. This party, Forward Guyana Movement, you will recall, days before the elections, filed a challenge in the High Court, claiming that GCOM wrongly excluded their name, from ballot papers. And that case was heard and determined by the current acting Chief Justice, Mr. Justice Navindra Singh. Of course, the Attorney General was part of the case, and I made submissions, as did GCOM lawyers, to the effect that there was a complete and utter misunderstanding of the relevant provisions of the Constitution and of the Representation of the People Act. I said publicly and in court that I have never seen such misapplication and misunderstanding of clear English language. Well, I am seeing that now, and I will speak about that later. But the judge upheld all of our submissions and dismissed the case. FGM then filed an appeal to the Court of Appeal, and that appeal was heard by the acting Chancellor, Justice of Appeal Rishi Prasad, and Justice of Appeal Naresh Harnanan. Acting Chancellor Roxanne George. Very experienced bench. So Navindra Singh told them that their case was hopeless, completely without merit, ridiculous, and dismissed it with $1 million in costs. They went to the appeal court, and those three judges used even stronger language. The judges say that the case was ludicrous, was wholly without merit, was an abuse of the process of the court, and accuse the FGM party and lawyers for not being candid with the court and withholding information. It was a tongue lashing of the highest order. Another $1 million cost was imposed by that court when it dismissed the case. That court also held that it did not have jurisdiction and that the proceedings should have been filed by an elections petition. That ruling was handed down on the 2nd of October, that's 2nd of last month. They ran to the CCJ and they filed a wrong proceeding there, and the CCJ didn't even entertain them. At the registry, the court sent back the documents. Now, they have filed now for leave to appeal to the CCJ, to the Court of Appeal of Guyana, as is required. So they are now getting it right. But at the same time, they have filed an election petition in the High Court. So now, the Court of Appeal told them, in the case that the Court of Appeal dismissed, on the 2nd of October, the Court of Appeal said, look, you're in the wrong court, and the wrong proceedings, you should have filed an election petition. They followed the Court of Appeal advice, and they filed an election petition in the High Court. Notwithstanding that, and though they have followed the advice, they are now appealing the Court of Appeal decision to the CCJ. And an application was heard for leave to appeal to the CCJ today. And the Court of Appeal gave certain directions in relation to that matter. And that matter will come up on December the 10th for arguments at 9:30. That is, leave to apply to the CCJ, to appeal to the CCJ against the Court of Appeal. But they still have an election petition which they filed in the High Court. That has to be heard. We have filed a summons to strike out that elections petition. The Attorney General has filed a summons to strike out that elections petition on a number of grounds. One, that they did not obtain leave of the High Court to file the petition as is required by Article 163 of the Constitution. And if you don't apply and obtain leave, the entire proceedings is a nullity. So the case is a non-starter from the beginning. But in addition to that, we are also contending that they didn't name all the parties. They didn't serve the petition properly and within the time required for that to be done. The petition itself is not in the prescribed form. That other statutory documents that are required to support a petition of that type are not in their prescribed form or have not been filed. And you know that elections petition law is very unique and peculiar. Any procedural error is normally fatal. The PNC learned that the bitter way with the two petitions that they filed after the 2020 elections. Both were dismissed within 6 months of their filing because of errors that were made by Roysdale Ford and the group of lawyers who were representing them. Remember that? They didn't serve on time, this wasn't right, that, you know the whole story. Well, this one is 10 times worse. And we have filed an application to strike it out. And we are waiting for a date for that. Now, you have, owing to the Attorney General, is $1 million cost for the High Court action that Chief Justice Navindra Singh dismissed, and another $1 million which the Court of Appeal granted when they dismissed the appeal. We have written to Vivian Williams and to Miss Fisher, whoever it is, whoever this person is, and we are requesting the $2 million costs to be paid, which the court said must be paid by November the 14th. November the 14th is Friday coming. In advance, we have sent out letters demanding payment in compliance with the order on or before November the 14th. It's $2 million to the Attorney General and $2 million to GCOM. That's $4 million. If these sums are not paid, at least speaking for the Attorney General, I don't speak for GCOM, decisive steps will promptly be made to recover this sum of money, including, decisive steps will be made to recover this money. Let me don't outline what those steps are going to be. So, that is the update in relation to those matters that I want to speak about. I am watching, trying to get your comments, but it's rolling up very, very quickly. Now, I saw a post made by Darren Wade, I think, yes, Darren Wade, in which he is making critical remarks about Jamaican lawyers being retained in Guyana. And quite frankly, it's a very foolish statement for anyone to make. In particular, Darren Wade, a member of the PNC. Off the bat quickly, I can remind Darren Wade that his Attorney General Basil Williams retained possibly the most lawyers in the Caribbean to represent losing cases that he filed for and on behalf of the APNU AFC government. You had Ralph Thorne and Gallup from Barbados. You had Jeremy and Keith Scotland, John Jeremy and Keith Scotland from Trinidad and Tobago. You had Ine Cortinet from Belize. You had Francis Alexis from the Eastern Caribbean. And I can't remember who else. And I just call a couple. But more importantly, so the PNC got to be the last persons to be speaking about retaining lawyers in the Caribbean. But you have to be, when you make these statements, you have to think, and maybe Darren Wade is not blessed in that regard. Guyanese by the thousands work and are still working throughout the Caribbean and have worked throughout the Caribbean for decades in every profession, including the legal profession. Guyanese occupy high legal offices throughout the Caribbean. The Chief Justice of Belize is a Guyanese. You have many Guyanese who are judges in the Eastern Caribbean. My friend Ralston Glasgow is a judge in Grenada. Many judges are Guyanese. Many magistrates are Guyanese. Many prosecutors and lawyers within the state departments of these countries are Guyanese. In Trinidad, you have a number of Guyanese practicing and holding different positions. And you can go territory by territory. How can you make such a unfortunate statement? Darren Wade graduated from a regional law school. We speak in Guyana and in the region about regional unity. We are pursuing common employment, in particular in the professional field, under the CSME arrangement. It's an extraordinarily foolish and backward statement to make. Maybe he will withdraw it and apologize. But I would like his colleagues in the Caribbean with whom he studied to see what he's saying about them, how insular he thinks. And we are building a regional law school here where we want the whole region to come. And here is this backward mentality being expressed and given some prominence in some quarters on the social media. I want to speak now quickly. I have about 15 minutes more. Persons who don't wish to hear what I have to say, persons who don't wish to see what I have to say, they are not invited to be part of my Facebook page and programs. Those who operate my Facebook page have drawn to my attention that an army of political trolls and fake account holders have been unleashed on my Facebook page in recent times. Obviously directed centrally by a political party who take umbrage with what I have to say as Attorney General. And they have unleashed an unusually high degree of ignorance and toxic ignorance and cussing and personal attack and abuse on my page. This page is not for that. I don't speak for that. Keep those things to yourselves. You don't have to come here and listen to what I say. But we can, civilly disagree. There are a certain number of people in this country and certain political elements that I will never be able to convince about anything. Up to now, there is a large grouping of people who believe that the PNC won the 2020 elections. You heard one political leader recently said that he won the 2025 elections. You have thousands of people who think that someone murdered the young lady, who died in the pool. No matter, forensic pathologists came from all over the world and expressed a different view. So there is a group out there who are puppets and are being used to attack people. And those gentlemen who are handling my page and ladies, they showed me the amount of fake accounts. As soon as you go to these accounts, there's nothing behind them. The 2 photographs and 90% of them locked. You can't even get to them. And I've told them to delete those things. People who are trolling and who are paid, and I don't understand that. You're paid and you operate 50 or 500 fake accounts and you use them to attack people. Just stay off my page. I don't speak to you. I can't deal with that. I can't help you to understand based upon the comments that they have shown me, because I don't read them. Based upon the comments that I have seen, that they have shown me that are being expressed, then those people are incapable of comprehension. And I'm not speaking to you. I can't speak to people who don't understand basic common sense and English. This program is not for you, and whenever I speak, you switch off. I am not speaking to you. I can't help you. I can't. So this program, and whenever I speak, is not directed to people with that level of thinking and that mentality. I'm sorry, Vice President said people were stupid and he got into some problems, but there are people who are stupid. Large number of them. All I'm saying, just keep away from my page. This is not about that. I speak to people who can comprehend and who can understand and who can reason. Now you can disagree with what I say, but at least you have to understand what I say to disagree. The comments I'm seeing from 90% of those who are disagreeing with me are incapable of understanding what I say. So you can't disagree if you don't understand in the first place. So I'm not speaking to you. Thank you very much. I love you and everything, but, stay away from me. Stay away from this page. Take your toxicity elsewhere. So, however, I still have to continue to try to educate people and put important pieces of information in the public domain. So I see a newspaper article arguing that there is no valid treaty between Guyana and the United States for the purposes of extradition. That is wholly inaccurate and should not be peddled in the public domain. That issue was decided many times by our courts. The treaty that governs Guyana and the U.S. in relation to extradition is a 1932 treaty that took effect in 1935 between the United Kingdom and the United States. When we became independent, as a sovereign nation, we inherited that and many other treaties and international instruments that related to British Guyana that were executed by Great Britain as the colonial power. Recall the 1898 arbitral award that settled our land border with Venezuela. That was 1898, that arbitral award that took place in Paris, and it came out of a treaty between the United Kingdom and Venezuela. It is now common knowledge that 1899 award binds Guyana, because when we became independent, we inherited that award. That treaty, as I said, was between Venezuela and the United Kingdom. And when we became independent, by the instruments of independence, we received those treaties and we benefited from all the agreements and all the determination, in this case the arbitral determination, that Great Britain had with various sovereign states as they relate to Guyana. So, and our courts have decided that repeatedly. I have a case here, a judgment of Justice Joanne Barlow, delivered only in 2017, in 2018, 5th of May, 25th of May 2018. And the lawyers who argue the case, one of them is Nigel Hughes, so they know these things. And they raise all these points over and over again. And Justice Barlow went through the history, as previous courts have done, and ruled that there is a valid and existing treaty between the U.S. and Guyana in relation to extradition, and that it is the same treaty that was executed between the United Kingdom and the United States in 1935. 1932, but took effect in 1935. Before that, Chancellor Kenneth George, the father of now Chancellor Roxanne George, made that determination and made that pronouncement since 1992 in a case called King against Director of Prisons. And that case is reported at 47 West Indian Law Reports at page 210. Then in Sobers against Director of Prisons, Chancellor Kennard, another Chancellor, made the same pronouncement. And in that case, Sobers against Director of Prisons, that case is reported, it was in 1999 and is reported in 60 West Indian Report, page 302. And when you read those judgments, learned, erudite judgments, those judges went to great length in tracing how we received that treaty and how we received previous extradition legislation. Under the independence order, under the Republican order when we became a republic, and these instruments continued. One of them even quoted a letter that Prime Minister Forbes Barnum wrote, well, Premier Forbes Barnum wrote, upon Guyana becoming independent. He wrote the United Nations, and he said, Guyana will continue to be part of all treaty arrangements entered into by Great Britain. So these are not new matters. I don't understand how. And that is what I'm speaking about. The level of misinformation that's being peddled. And these things can be easily found and confirmed. And as I said, they have been decided by different courts at different periods. The Extradition Act itself, the Fugitive Offenders Act. The Fugitive Offenders Act, Section 4, speaks to the treaty. It says, it speaks to an arrangement between, read Section 4, and you will see that it says, it speaks to an arrangement made between the government of the United Kingdom and the government of a foreign territory relating to extradition of fugitive offenders prior to the 26th of May, 1966. That arrangement extends to and remains in force in Guyana. That is the treaty they're referring to. Entered into between the government of the United Kingdom and the government of a foreign territory prior to the 26th of May, 1966. And that it remains in force. Our Parliament has stamped its validity to it. And this act was passed since 1988. And every extradition that is done, the Minister of Foreign Affairs, under this act, I think it's Section 6, is required to produce a certificate to say that the extradition treaty that exists between Guyana and the country that is requesting the extradition, that treaty is in force and is valid and binding. That is a provision in Section 6 of the Act. Let me read it. A certificate issued by the Minister assigned responsibility for foreign affairs or on his behalf by any person authorized by him, confirming the existence of an arrangement referred to in section 4.1. That is the section that I just read to you. And that arrangement extends to and remains in force in Guyana, and stating the terms thereof. So Minister Utad had to issue this certificate to say that there is this treaty, and that treaty is valid and in force. And he had to attach to that certificate a copy of the treaty. That is in the bundle that was served by the prosecution on the defense. And yet, the ignorance that I'm overwhelmed with, that there is no treaty. They were saying that there was no extradition request. They were saying that there was no document from the United States. We made up all of this thing. Now they're saying that there is no treaty. We have some special people in this country. Well, we love all of you. All I ask is, when you're that stupid, don't come on my page, please. I'm entitled to ask you that. And I hope that you will respect my wishes. I want to thank all of you for spending the past hour with me. I believe that we have covered some important issues, and I hope that I have answered some of your concerns. I have answered some of the issues that you would have liked me to address. And I am sorry that I didn't speak more on the extradition matter. I know many of you want me to speak again on it, but I have said enough. I have said enough, and there is a deliberate strategy to denigrate what I say on this matter, to attack what I say, to attack me for saying what I'm saying, and a deliberate strategy to mislead and to spread misinformation. And that is a strategy that they are pursuing, and you must know that by now. So I am going to say what I have to say, and we'll move on. I have said enough, and I speak to you, the people who can understand what I'm saying and would like to understand what I'm saying. I am not speaking to those whose minds, who are paid to do the things what they're doing, to say the things that they're saying. Thank you very much. May God bless all of you, and I'll see you next week. Thank you.